The biggest worry for most employers is finding themselves in an employment tribunal, especially when they think they don't deserve to be there. This webinar is designed to give you a framework within which to operate and some really important key pointers to make sure that your processes, procedures are correct and watertight, that you've trained your managers, your supervisors and your directors in the right way to behave. And above all, it gives you a framework within which to make sure you are treating your employees fairly, with respect, and in a way that means they're not going to come after you later. Sure, we can't cover every single topic, every single problem, but there's a very useful top 10 tips and some banana skins that you should be avoiding. We hope you enjoyed the webinar. Look forward to seeing you again soon. Good morning, everybody. Thank you for attending another one of our focused webinars. This time we're focusing on keeping out of tribunals. And I suppose before I start, the only thing to say is traditionally you could probably say the only way to absolutely make certain you kept out of tribunals was by not employing anybody. Nowadays, with the extensions of things like agency workers' rights and third parties and subcontractors, that's probably not even possible either. You will have a relationship with somebody that could potentially leave you facing an employment tribunal. Today's webinar is not to give you an A to Z of how to make sure you keep out of a tribunal, because we might be here for 3 or 4 weeks doing that, but is to give you some strong pointers and a framework within which you can operate and pretty well operate safely for most of the time, and how to deal with unexpected situations when they come along. So as people continue to log in, we're Backup HR, real world business solutions to HR problems. My name is Guy Liddell, Managing Director. Kathy, unfortunately, can't be with us today, but I am joined, as ever, by Peter Stanway, who is here to help me with the presentation, cover some of the much more difficult and much more intricate areas, and also to answer any questions that you have at the end of the session. We anticipate this being 40 to 45 minutes with time for 15 minutes of questions at the end. If there aren't any questions, and I very much doubt that, then we do have some extra items to cover at the end that you should look out for. As ever, and those, particularly for those who are new to us, if you want to ask questions while the presentation is going on, there is a chat box on the right. Please ask your questions in there. It is a moderated chat box, so they won't immediately appear in public until somebody in the background has had a chance to take a look and just make sure that they're relevant to the topic today. So without further ado, let's get going. I'm just going to cover some ET stats, Employment Tribunal stats to begin with, and then we're going to give you what we consider to be our top 10 tips on how to keep out of a tribunal. Some of the banana skins that you potentially might think are perfectly okay but aren't. And if we have time at the end, and if there aren't many questions, we'll point out some areas when it's time to really concentrate and make sure you get everything right. We've probably all seen the headlines around about a tribunal system in chaos, that the coronavirus pandemic has caused what lots in the media are causing a perfect storm, and that over the past year there have been far fewer tribunals around than there should have been. They are beginning to recruit extra judges, and they are beginning to use video technology to overcome this problem, but the backlog still remains. We reported, I think, in September that cases were up 27% year on year. There were 42,000 live cases at that time. which was 6,000 higher than the previous 12 months at that stage of the year. And that means that if somebody does take you to tribunal, then this is a problem that will hang over your organization for probably now at least a year. If you look at before COVID, there was already a significant backlog. That had risen to over 30,000 cases in March, 36,000 cases in June, and over 40,000 cases backlog by September. Those are significant figures and are not surprising, really. The disruption from COVID had made a workforce much more nervous, added to which lots of employers had acted in haste. There were plenty of redundancies around, especially in April and May last year, some of which could have been contentious and some of which might have been inadvertent discrimination, making people redundant who'd been on furlough, etc., which we think will cause a problem when they get to be challenged in the courts. We are already seeing COVID cases starting to be heard. There was one this week, and I think there are two significant things about that case. I've read through the decision. It was an Employment Tribunal decision, so it may go to appeal and be challenged. But it was about face masks and somebody a delivery driver not wearing face masks when they went to a third party who required them to be worn. Two significant things. If that had been tried this time last year when there was no science around face masks at all and the government was very ambivalent, the decision may well have been different. So the person was acting at the time on information, I suppose, that was based on what was the norm at the time. Even so, because we know far more about COVID now, the courts have looked at it and felt that the employer did behave reasonably, and it was a reasonable response to ask the employee to wear a face mask. I'm not going to go into any other further details of the case, but the other thing was that the investigation that the employer carried out and the facts were not disputed by the tribunal. So that the importance of an investigation and going through the proper process meant that actually the case went against the driver and they found that the dismissal had actually been fair. So just to let you know, there are some already going out there. So this is what we're talking about, waiting times, and bear in mind that this is up until September last year, and they reckon that the backlog is increasing by 1% a month at the moment. If you go through these since last September, we're now in February, so that's 5 or 6 months. So it may well have gone up by 6%. So there may well be 2,500 added to this backlog by now. It may be even more than that. And these are the sorts of legal challenges that have popped up from the pandemic, things like redundancy selection, things like discrimination, especially with regard to furlough and with regard to redundancy selection, around age disability, working parents, especially mums, because 70% of mums have been handling the parental responsibilities, and within certain sections of the community for whom coronavirus presents an even greater challenge than it does to the general population. We've already talked on a number of our webinars about health and safety detriment and individuals not happy about what's happening at work and whether they're properly protected, and playing a couple of cards, the serious and imminent danger card, which is obviously quite right, and indeed whistleblowing about health and safety and employers ignoring that whistleblowing. And now we've got a new one around vaccination and can I sack somebody for not getting vaccinated, and that whole debate, and there will be legal challenges around that, and obviously around national minimum wage, furlough and pay. So lots of things happening there. So what are the fundamentals that we're going to talk about today? And the fundamentals are that if you as an employer, as an organization, observe these fundamentals and follow them rigorously, that you should be at least better protected than those who ignore them. at the base, underlying everything is good documentation, which we'll talk about, and making sure that particularly your management and supervisors follow procedures, especially those laid out within your documentation. Being fair and consistent with your workforce and doing it with good grace. We'll talk about this later, but an awful lot of employment tribunals end up because people just don't like the way they have been treated and feel they have been treated badly and want some redress. And finally, the sort of icing on the cake is if you go through all of that, make sure that whenever you do something, you offer an appeal. And if you are uncertain about anything, especially if you're doing it for the first time, you make sure you take professional advice. So that's the basic that underlines everything we're going to talk about today. And I'm going to bring Peter in here to start talking about tips. Good morning, Peter.
Good morning, Guy. Good morning, everyone.
So without further ado, let us go to our top 10 tips. And our top tip number 1 is to make sure that you get your documentation right. Peter, you deal an awful lot with documentation the whole time, contracts, policies, handbooks. Let's just talk through a little bit about what underlines what organisations should be doing here.
Well, you've got to supply a contract of employment, and these days you've got to provide it on day 1, or better still, earlier. So you've that's just a legal requirement to provide that. The theory being that if you've got that right, you're much less likely to have problems. That's the legal theory, and the same theory, although not quite from the same legal perspective, if you've got a good set of policies and procedures, preferably in a handbook, then you are also likely to be, well, A, in theory, that's what you go to. You get a problem, you follow your procedure. And B, if you've done that and you've got it, then the tribunal are going to say, yeah, you're nearly there. Obviously, any other communication outside of that is also important, especially if it's in writing. The key thing is that they clarify standards, keep people up to date if you're changing working practices, and they show a professional image. And tribunals, they won't completely protect you, but if you look like you are an employer who's doing things properly, then you're just creating a better first impression. Yeah,
and I think particularly, and I think we'll talk about it on the next slide, you did mention it, but they changed the law in April last year, and we know plenty of employers who used to ignore the old 8 weeks. You had to get the particulars of employment, a statement of employment.
Out to people. And often that was too late. And we've had several unfortunate experiences where if people had done it earlier, they'd have been in a much better position to defend claims of one sort or another.
Yeah, indeed. But now that has to, a contract or something laying out all of the particulars of employment has to be issued by day 1. And as you say, it's by day 1, preferably do it before with your offer letter or your follow-up documentation.
Yeah. So the key thing there is about laying out your key policies, and we didn't have room for all of the sort of policies that we would put into most employment handbooks, but those would be the key ones. And I suppose if I had to focus on 2, it would be equal opportunities and the dignity at work policy that goes with it, and discipline and grievance, because that's what you should be doing, and that's because the law requires you to set out what your discipline and grievance procedures are. They do require health and safety, but you could get away with having your health and safety policies and procedures elsewhere.
Okay.
But there's a long list of important things that you ought to have there, because they're supposed to be a guide. And there's no good hiding them away and saying, well, they're our policies and procedures. If your employees say, well, I didn't know I was supposed to do that, or
No, and I
just
think the
give
point
them
about a
trust.
handbook, and we is one, they need to be kept up to date, and we update all of our client handbooks at least once a year. But the other point about a handbook is you don't have to have a handbook, but the handbook keeps all of your policies together in one place. Okay, so that's top tip number one. You may recognize this: education, education, and education. Policies, it doesn't matter how good your policies are, if your managers and supervisors don't know about them and don't know how to implement them, they're not much good. And it is essential, and probably the most important people we find very often are the directors of the business, first of all, or the senior trustees, or whoever sits at the top of the organization, that they understand and know that they, just because of their position, they can't ride roughshod over policies and procedures. But then managers and supervisors also need to be trained. And if you are going to train them, and make sure you keep records to say that they have been trained. And I think, Peter, down here, we say employees don't need training on everything, but communicate them important changes. So if you are changing a particular policy on discipline or grievance and subtly altering it, your managers need to know, but it's not necessarily that the employees need to know until they come along to do them, so long as it's documented. And you just communicate your employment changes as and when they become part of their terms and conditions of employment, I suppose.
Yes, it's difficult when you get into employees saying, "Well, this is the handbook I got in 2012." Well, there's no record of me being given a more recent one. Awkward and slightly embarrassing.
Okay, so keeping people up to date and issuing new handbooks as and when it is updated, or at least people knowing where to look for it. Okay, top tip number 3. Peter, do you want to talk us through this? Because I think jumping to conclusions is probably what we're all guilty of at some stage in life. In employment law terms, it can be quite dangerous.
Yeah, we've written the slide in the context of disciplinary action, but the same logic, well, not all of the bits on the slide below do apply, but often we'll get clients saying, we want to do a redundancy selection exercise, and Fred and Bert will be going as a result. And the reaction to that is, well, don't jump to those conclusions. A, it's dangerous legally, and B, there are occasions where people have done a redundancy selection exercise properly and said, oh, Fred and Bert aren't all that bad, but these two are our worst performers. So the principle reads across, but certainly it reads across into disciplinary action. So the key thing is to have a full, thorough investigation. It's almost become the first mandatory stage in disciplinary procedures. In what I would call the good old days, in inverted commas, I'd quite happily drag people into the office and we'd investigate and discipline all in the same process. It's very difficult to do that these days, other than for minor infringements where you're just going to tell people off. You need a good investigation, preferably using someone else. And I seem to spend a good chunk of my life talking to clients who say, well, we've not got many managers. So who's going to do what? Can you find someone to investigate, someone else who will then deal with the disciplinary action, and someone else, preferably more senior, who can be there for an appeal? So when we say an independent person, we don't mean dragging in an HR consultant or whatever, but someone who's going to look at it reasonably independently and thoroughly. Part of not prejudging is checking all the documentation, pinning witnesses down, getting stuff in writing for them, preferably getting signatures, and getting things dated. So you've got that solid evidence base, which you may well need later. And ultimately, before you dismiss, even if you're absolutely 100% certain of the facts, and you don't need to be 100% certain, you just need a genuine belief that misconduct has taken place. And that needs to be on reasonable grounds after a reasonable investigation. But you've still got to say, what is the right thing to do in these circumstances? Just because we started off with a vague presumption of dismissal doesn't mean it has to happen inevitably. And we'll cover that in some of our other slides.
Yeah, indeed. Yeah, we do cover it. And I mean, we talked about this earlier in terms of, you know, if you are investigating and making sure you don't jump to conclusions for at least a short period of time, there's rarely a case where it might not be appropriate unless somebody could be moved somewhere else within the organisation that's completely separate, and very large organisations can certainly manage that, is that suspending somebody on full pay for, say, a week while you investigate may be appropriate, especially in very serious cases. I
think especially in very serious cases, what we don't want to give the impression is you've got to suspend someone because they've not phoned in properly to say they were sick.
No, exactly. Or they turned up late for work again. You know,
it's only if there's a likelihood that dismissal would be a potential result.
And I think you actually said, but this doesn't mean to say, like we've seen happen in some educational establishments and in some NHS trusts where surgeons or head teachers or something have been suspended for a year while it's investigated. That's not what we mean.
That's not what we mean. What we are slightly resistant to is the sort of modern view that you just shouldn't suspend. The official guidance is don't do it as a knee-jerk reaction. But that is a response to the greater sin of having people suspended on full pay for months, if not years. You're unlikely to have a problem if you've done it and you've dealt with it in the week.
And we'll talk about proportionality later in terms of the action, but proportionality is important here, isn't it? It may be a proportional action.
And I think investigation has to be proportional, and there is a slightly modern tendency to go over the top of investigation. This has to be proportionate. You know, you might spend days investigating a incident that could well lead to dismissals. You're not going to spend days investigating why someone was a bit late phoning in sick. Okay,
and just as a warning, as well as not jumping to conclusions, never dismiss staff on the spot or in anger. You know, it doesn't.
There is no such thing as instant dismissal.
No,
it's a euphemism for summary dismissal, but even summary dismissal doesn't mean doing it on the spot.
So, following procedures, and again, you know, there's almost an automatic assumption in tribunals, I think, that if you haven't followed, especially your own laid down procedures, then in almost all cases that dismissal will be unfair.
Yeah, that is absolutely the case. I get slightly nervous about the term automatic because automatically unfair is a specific legal category. But the chances of winning if you haven't followed your procedures properly are very slim. It'll have to be a minor issue that the judge almost decides to blind eye. And I've come across that in the past.
We have seen cases.
You don't want to rely on it.
We have seen cases where the tribunals have said the outcome would have been the same had you followed the procedure or not, but that's a very dangerous route to go down.
That only goes to the issue of compensation. It's still an unfair dismissal that you can probably argue that they shouldn't get so much, but that I don't want to go into that issue.
No, fine. No, the idea is you follow. If you've got a procedure laid down, then make sure you follow it. And if you haven't got a procedure laid down, then, as we always say, then use the 3-step procedure, especially if you're going to call somebody in for a meeting to discuss an issue about something. And so we'll move on to top tip number 4 is follow your procedures. And the 3-step procedure would be particularly useful for those with less than 2 years service who may be outside your normal, and in fact, for most of our clients with their handbooks, are outside their normal disciplinary procedure. So, Peter, the 3-step procedure, and I suppose if you're doing an investigation, this turns into a 4-step procedure, but the 3-step procedure is that you've identified an issue that is of concern, or maybe a disciplinary issue.
And so they've seen it in writing, and they've had some time to absorb that and think about it and sort things out, like the right to be accompanied. So once you made them aware, you invite, and you can do it at the same time, but invite them to a hearing. And the key thing is to have a reasonably fair hearing. It doesn't need to be totally thorough and lengthy, but it's about giving people an opportunity, because often open and shut cases just aren't. They hear a perfectly good explanation and think, oh, why were we getting excited about that? We understand it now. And you've still got to think, well, okay, well, the facts are still the same. You've still got to think, is it right to dismiss? Obviously, you confirm that in writing, and you offer an appeal. In my experience, up until the last year, hardly anybody ever bothered with that, certainly in terms of people with less than 2 years service. There has been a slight upturn in it this year, and I think that's because people are much more desperate to try and get their jobs back in the current climate, understandably so.
Okay, and when you say there's not been much of an uptake, is that appeals have been offered, but not many people have taken the employer up on the idea of actually having an appeal?
Especially if you've done that bit right first. If you just drag someone in the office and say, what have you got to say for yourself? Not good enough, you're sacked. They're not going to feel they've been dealt with fairly. So they are likely to appeal. If, on the other hand, you've spent, and I wish I'm slightly nervous about saying this, half an hour with someone going through something and going away and thinking about it for half an hour, and you've dealt with, and I know we're overlapping with other things, you've dealt with them in a respectful manner, they're probably not going to bother with an appeal, because they know, that you've got them, for the want of a better term. Some people do, but very few if you've done it properly. Okay.
Some of these may seem very obvious, but actually, our experience is, and if you look at employment tribunal claims, fairness and consistency, constructive dismissal is a particular concern where employers are not fair and they are not consistent. Have you been fair to that? Objectively, have you been fair and the action you've taken is proportional with the individual? But more importantly, how did you deal with this the last time somebody bashed somebody on the nose? Did you say, oh, that's just the way John is and forgive it, but it's not the way Brian is, and sack him pretty well on the spot? So being consistent, a bit like legal precedent in law, is an important thing, and things that employment tribunals value quite highly.
It is important. However, I think fairness is more important than consistency, and people do tend to confuse the two.
Indeed.
And I would rather be fair. Just saying, well, we sacked the last bloke who punched someone on the nose, ignoring the fact that he'd been with you for 6 months and he was just violent, and you're currently dealing with a person who's been with you 25 years and doesn't have that history and was seriously provoked. If you were being consistent, you'd be wrong.
Yes. So it's being fair and it's being consistent. So in similar circumstances, did you do the same thing?
Yeah. And almost the same circumstances, and circumstances are never quite the same, but
no.
Difficult area, but fairness is more important than consistency.
And Peter, proportionality as well. We've talked about it before in terms of investigations.
Yeah. Often we get the issue of people saying, I want to sack them for that. And you think, hang on, this is not a proportionate response. It's probably a written warning, possibly a final written warning. But, sacking someone for being consistently late on its own, without a very good history of warnings and chance to improve and whatever, is probably not proportionate.
And the underlying principle is that serious issues should be treated seriously.
Yeah, in terms of how you deal with it procedurally and your decision making.
Yes. And if it's a first offence, then it's rarely a case for dismissal unless obviously clearly you've got listed, you've laid out very clearly what your gross misconduct policy is in your handbook and your documentation, and it is clearly gross misconduct.
Yeah, and it's still proportionate. Sacking someone for taking the company pen home is probably not proportionate. If they've got a box of pens in their handbag or jacket pocket, it might be proportionate.
Yes, indeed. Indeed. If their Saturday sideline is a stationary operation that is supplied by
even more so. Yeah, and you've always wondered how you managed to use so many pens.
Yes.
Yeah.
Okay. And again, this comes back down to proportionality as well, but mitigation.
Yeah. Long service, particularly good service, is important, and whether they've actually recognised the seriousness and are properly remorseful. People don't use remorse as a word these days, but it is important. And I've always said, it's very difficult to sack someone who reminds you about their 25 years service, their previous good record, their terrible current personal circumstances, their regret, and their promise that it will not happen again. You've got to be pretty hard to say, not listening to any of that stuff, you're sacked.
So considering mitigation, and that's the case when you're using your 3-step procedure as well, isn't it?
Yeah, you've still got to consider mitigation.
Yeah.
A 18-year-old who does something daft on social media is not the same as a 40-year-old manager who should know better.
Yeah. We talked about appeals right at the beginning. That was very much at the top of the pyramid. Yeah. You've talked about it through, and I think that one of offering an appeal, almost whatever you've done, and there are certain, I know, technical circumstances where you don't have to offer an appeal, but the right to appeal, broadly speaking, is essential, and it can't do any harm if you offer an appeal. Whatever.
Well, unless you make it worse. Yeah, it is possible to make a perfectly good dismissal worse by a really bad appeal, but that's rare. And most importantly, often good appeals can make good, not very good dismissals. So it's an opportunity to put things right if you've not done things as thoroughly as you should have done in the first place.
And I think one of the things that I don't say surprised me, but that you pointed out is appeal cannot give out a harsher income than the original outcome than the original outcome, unless new facts have come to light clearly. But based on the same set of facts, you can't suddenly say, well, it was a disciplinary, but now we think it's a dismissal.
Yeah, that would be very, very foolish.
Yeah. So the only way you can overturn the original decision is in favour of the employee and not in favour of the employer, so to speak.
Yeah.
Record keeping. And we know this because I've seen bundles going off to employment tribunals of documents, and bundles that stretch to hundreds and hundreds of pages, which is one of the reasons why employment tribunals are so costly and take so long. But employment tribunals do love to be able to see and handle facts and not just listen to witnesses in the box, so to speak. And the bundles that we have handled certainly are minutes of meetings and of hearings,
Yeah.
Letters and emails that relate to the case, perhaps even unrelated to the actual individual, but between managers, written evidence and photos taken of, the place where the incident took. And I think even, Peter, you were talking about somebody who was accused of taking a transformer from an organisation, and you were suggesting they actually took it into the tribunal to prove that it actually couldn't have just fallen into their boot accidentally.
They were allowed to have the transformer, but their argument was it just bounced out. Well, a transformer, in this case, was about the size and weight of a car battery. So the chances of it bouncing out over a car 12-inch sill was minimal. But if you just said it was a transformer, well, judges and tribunal members aren't necessarily going to know what it means. Transformers, they may think, are those things that kids play with, or they make films out of. So they like evidence. It's a shame that they don't quite have a dagger and blood in a plastic sleeve, because if you had that, that would be great. But that's the sort of thing they like. Exhibit A.
Yes. And also there is a presumption, or there does appear to be a presumption, that if the employer in particular can't prove a fact, then they almost disregard it as happening.
Potentially, yes. Yeah, that's the risk. So that's why you need your evidence.
Yes. Yeah, so strong record keeping.
Because tribunals know that people tell lies, or would like to think that that's what they did.
Yeah. And obviously the importance of correspondence, providing the employer has acted reasonably under the circumstances, will generally show that they've acted reasonably under the circumstances, and will show the arguments that were being considered leading up to the decision that they took. Unless, of course, the evidence says otherwise. And that's one of the things I think that, again, you and Kathy...
What I would say is be very careful about what you say and do in emails, because potentially that's going to come out. And if there's an email saying, well, who's going to sack the bastard? You should show that to the other side, and they're likely to think that it would be a good idea to include in the bundle.
Yeah, because you are obliged to provide all evidence to the tribunal. That's correct.
Yeah, they are, and there are serious penalties for not doing so.
Right.
And it's not just show the good bits, it's show everything. Yes. If you end up at tribunal and you're into disclosure. All the more reason for trying to settle earlier if you've got a whole heap of embarrassing emails.
Indeed. And it's probably one of the places you should look if you start to get challenged.
Yeah.
Apologies for what looks like an inappropriate photograph on the right-hand side here. This is actually Funboy 3, and it was their song, which neither Peter or I are going to sing, but it ain't what you do, it's the way that you do it is hugely, hugely important. Not necessarily to the Employment Tribunal itself, but actually as to whether a claim ends up there. And I think we've all heard of hospitals being sued by patients or their relatives because they never got an apology and because of the way they had been treated. People going to tribunal very often end up going there because they really do feel that they were treated badly, they weren't shown the right amount of respect, or that the employer was just ticking a few boxes to get them out of the door because actually they'd been looking for years and years and years for an opportunity to get rid of them. That's where a lot of these cases end up in tribunal. So
I've actually had people thank me for dismissing them, not because they were grateful to be dismissed, but they actually appreciated the way they've been treated. Doesn't happen very often, but that's what you should aim for.
I've had a comment come in on the MetaReady chat to say that is Bananarama, not the Funboy 3. It's actually the Funboy 3 dressed up as Bananarama, but that's a different argument. I took it off their YouTube video this morning, so there we go. Movie.
I wouldn't normally argue with that person because their musical knowledge is very good, but I defer to your research, Guy.
Yes, indeed. Peter, perhaps you can talk about how people can try and...
It's about, the time. I still get amazed when I've talked through issues with clients, and then you look at the notes, and the meeting lasted 10 minutes. And there's half a page of notes, and you think, have they dragged that out, or is it a very poor note taker? The time is important, not just in terms of how it looks, but how people feel. So tribunals will also look at the way and think, you look at those notes and you think it's not the way they're written. They've clearly been they've clearly been driven by someone who was just going through the motions. They can see through that. They'll be driven by their emotions of, would I deal with that? Now, they're not supposed to, but they do.
You used the example a little earlier on with me of somebody was accused of doing something and it was probably on CCTV and they'd been with the organisation for 25 years, but they couldn't spend 5 hours looking through the video to check whether the information was correct or not.
Which is, strictly speaking, a investigative issue, but
yes,
it does show a certain lack of care that an experienced manager who may struggle to get another job because they've been dismissed for irregularities and they haven't spent 5 hours looking at CCTV, which would have probably proved it one way or another. And I'm sure that though that particular company spent a lot more than 5 hours preparing for tribunal and being in tribunal and going to a employment appeal tribunal.
Yeah, indeed. The fact that you've taken the amount of time and the amount of care and treated people properly means that people may well recognise that they have been treated properly.
At least they've treated me like an adult,
Yes.
and they've been respectful. And it's easy to say, but it just makes all the difference.
Mm-hmm. Our top 10 tip number 10 is if you get it right first time, you'll have to spend a lot less time dealing with the fallout.
Yeah.
And it's especially important if you're facing something for the first time and you are definitely unsure of what to do, is make sure that you're very well informed on it and preferably get good professional advice. Spending an hour with a professional is a lot less than spending £20,000 defending a tribunal.
Yeah. Much rather someone say, I'm thinking of doing this, Peter, is it okay? Rather than, I've just done this, Peter, is it okay? Because sometimes it isn't.
No, and that's why our blog that we update from time to time called You Did What came about. Briefly here, we're going to just talk about some banana skins because there are some areas where you think you've probably got everything covered. And indeed, I dealt with somebody fairly recently who sort of wanted to make somebody redundant because they kind of weren't performing properly and they behaved badly, and they really wanted to skewer them on all three of those. And were, well, it's not a good idea, is it?
No, you'd preferably go with one. I mean, your redundancy might be based, your criteria might be due to that include previous conduct and performance, but you don't muddy the subjects. Tribunals don't like you saying, well, we made him redundant because it was kinder than doing the other, or we made him redundant, but the tribunal can see that really you thought it was just an easier option than performance management or conduct dismissal. or conduct.
And then things like, the team did not really like them and so on and so forth, especially with people who've been with you for more than 2 years.
Well, often that's even more of a problem with people less than 2 years, especially if that person was of different ethnic origin or the wrong sex, for the want of a better term, women in a traditional male environment or vice versa, or it's those sorts of things that you think, yeah, having a good fit with a team and so on is important. But if it's really a euphemism for they weren't one of the lads, they weren't like us, that then you're in dangerous territory.
And indeed, there was a case in the NHS very recently that was very expensive to the NHS, where an elder employee was actually refused the job because they wouldn't fit in with a younger team. When you're dismissing somebody, obviously, we talked about mitigation before, but it is easy to just not ask for it. Are there any mitigating circumstances? And when it is, dismissing it out of hand, saying, well, you might have been with us for 25 years, but... and the same with evidence in terms of tribunals just not having it, and you go to all the trouble of getting the evidence and then forget to keep it, which is something that we've seen before as well. Peter, there are 4 misconceptions down here, and I think these are serious banana skins. We talked about people with less than 2 years service with no rights, but it is important that they do have rights, and we've talked about the 3-step procedure. Perhaps you just want to
the key rights are discrimination and not to be automatically unfairly dismissed for raising health and safety concerns, or that they have whistle-blown, and it doesn't take a lot to be seen to be whistleblowing. I know someone who describes whistleblowing as the 10th protected characteristic, which is not legally correct, but it's become a factor that people with less than 2 years service will say, well, it's not age, it's not sex, it's not race, but I did have a good moan about the health and safety, or I moaned about them. I thought it was wrong that they were spilling waste into the local river. Great. That's just a godsend for their solicitor. They're only attempts, so we can do what we want. Well, all sorts of fixed-term contract people do have rights, so just because they're a temp doesn't mean you can deal with them badly. And that can also include agency temps. We know of at least one recent tribunal where officially the agency got rid of somebody for allegedly moaning about health and safety. And it will come back not just on the agency, but the employer. So just because they're agency people doesn't mean they're not a problem. Just be careful. It's easy mistake to make.
And we did a right to work webinar recently, which is now available on YouTube, by the way, on a Backup HR YouTube channel. You get phoned up and you're told that so-and-so is working illegally because they have no right to work in the country. So not unnaturally, I think most employers will say, well, they need to leave today.
It's a reasonable reaction, but probably misguided. The Home Office, A, get things wrong, and B, they don't make employment law and policies. So we certainly know of one employer who quite a few years ago appeared to do everything right, but because that person had then got themselves, I think their husband had got a student visa or something, if the employer had done it properly, they'd have found out that they did have a right to work. So you've still got to deal with things properly.
Yeah, and there are indeed, I think there's quite a lot of case law around about people who definitely didn't have the right to work, but were still unfairly dismissed because the employer didn't go through the right process.
Yeah, sadly so.
Which seems perverse. There you have it. And finally, and this is a technical banana skin, going through all of your redundancy process absolutely fine, but having sorted out your selection criteria, you don't give people a chance to challenge the basis upon which they're all being judged on, essentially.
But there's two opportunities there. One is them saying, I don't think you should use attendance because your records are rubbish, or my poor attendance is because I've got cancer. And you know that, or you don't know that, but I'm telling you now. And the second one is, right, we've done the exercise, we've done the scoring. What have you got to say about it? Well, it's terribly unfair. I'm much better at that than you're saying, so I want to appeal against that selection. And it's easy to overlook, but dangerous.
Yeah, okay.
And most people won't challenge those criteria. They probably should, but they don't.
Okay. And listen, you talked about this a little bit earlier, and you talked about investigation thoroughly, but you talked about health and safety concerns. We've used the example of COVID here because COVID is very much in people's mind, but it could be health and safety concerns about the company's use of chainsaws or whatever it is.
Yeah.
Employers just simply failing to investigate or consider harassment and bullying accusations, whistleblowers, and the one that we covered when we were working with home workers is just flatly saying, I want to work flexibly, and the boss going, I'm not letting anybody. Yeah.
And then they phone me and they say, what should I do next? And the answer was, well, you should have read your flexible working request policy. That's what it's there for. Now, how are we going to get ourselves out of this situation? Are we going to say, oh, that's just first reaction, we're now going to go back into procedure and consider it properly? Or are we going to say, well, we've given a sort of proper decision, but we're going to have a proper appeal, which is going to deal with it properly this time?
Okay. Finally, about discretion. And Peter, you're better off talking about this than me.
I quite like having discretion in all sorts of procedures, including sick pay, but it does make you liable for someone saying, you paid him for being sick, but not me. It must be because I'm a woman. And you've got to be able to justify it then, because you may have, it's probably not because they were a woman, but it's bloody difficult to prove that it wasn't.
Yeah. These are the sorts of things that employment tribunals hate, where you haven't had enough process, you haven't gone through the right process, there's no evidence. We've talked about these before, and not enough consultation with people when they were meant to be consulting. People going through box ticking exercises. If you're going for redundancy selections, then actually pre-selecting your victims beforehand and making sure that all your selection criteria fitted around who you wanted to get out of the organization, or merely saying, well, I don't think they're very good at that, rather than putting in a selection criteria that's based on figures or numbers or something that's objectively measured. Discrimination is clearly a really dangerous one, not least because damages are pretty well unlimited there. And the old catch-all phrase, well, we did that because we didn't have any alternative. And that might be in terms of redundancies, that might be in terms of dismissals. We were backed into a corner. Anything more to add about there was no alternative, Peter?
I hate that phrase. It just makes me nervous. I immediately strike it out of draft dismissal letters, because there's always an alternative. You might want to say there wasn't a good alternative because, that person was irredeemable, or we got no vacancies anywhere in the current climate, so there wasn't another job they could do. But it's just, it just brings back visions of Maggie Thatcher at her worst, I'm afraid. And I
yes,
it probably does for certainly the older employment judges.
Okay. And if you do find a situation escalating, just remember that even when you've got a formal employment claim, at least 22% of them on current figures are settled before tribunal. They think that's going to go up to closer to 35%. There are plenty of people out there who can help ACAS with their conciliation service. You can consider mediation. I'm a qualified mediator, and I do some mediation, not massive amount, but some mediation. So training people to do it internally. And there is judicial mediation that is used particularly in discrimination cases, which is found to be particularly effective. Arbitration and settlement agreements, which are our top 10 tip number 11. Settlement agreements. We've talked about these before. Peter, briefly, because we are running up against our 1 hour time here, but
you've got to do it right. Doing it properly will get you there, as will being appropriately generous, for the want of a better term. I don't like the word generous, but that's probably people think I mean. But you need to be sensible. Yeah, offering someone an extra week to do a settlement agreement's probably just going to annoy them rather than soothe them.
Yeah. Okay, and it's something that you really can't do by looking it up on the internet. You do need professional advice to do one of these.
Well, I've seen people try to do it themselves, either in terms of the handling and not very well, or they found something on the internet and they think it'll do. Yeah, drafting settlement agreements, not least because the other side will just think you're an amateur and you're going to be a pushover. Whereas if you drafted something really well, then it says to the other side, don't mess.
Okay, and we add on the end of that, and this is our top 10 tip. The graphic's gone a bit wrong on this. Number 12 is, if you are going to part with people or dismiss people, our work again side is doing quite a lot of outplacement now, and one of the things it does, it's relatively inexpensive. In fact, it can be very, very inexpensive at the lower end, just helping with writing CVs. But it does give employers better protection. It's good for your reputation. But if you get people back into work, and good outplacement does work, if you get them back into work, they're much, much less likely to come along and say, I'm going to take you to tribunal. And we've seen a number of cases of people who thought they were at the end of their tether, got themselves back into work and found themselves back in a better position than they were with the previous employer. So it is something that genuinely works.
And it helps, because if someone gets a job in 2 months, you know pretty much what the maximum compensation is.
Yeah.
If it takes them 6 months to get another, well, you know then, because it will be sick. It may even be longer by the time cases get to tribunal and people are still not working. But.
Okay. In conclusion, good documentation, follow your procedures, do it fairly consistently and with good grace. Make sure you always offer an appeal in the right circumstances and take professional advice. If that's the basis upon how you operate, especially by being fair and consistent, then you are much, much more likely to stay away from employment tribunals than those who continue gung-ho and think that's the way we should continue. Now we've got not very many questions, but we do have as the tribunal system is running, so the tribunal system is running behind, and we know there's a 40 to 50 week delay probably. If somebody was made redundant last July, would we have been notified by now that they had lodged an application for a tribunal? I think I know the answer, but I know a man who does.
99%. The answer is you would have been told. The only doubt would have been, A, there's delays, but not that much, and B, they can take a late claim if there are really compelling reasons for it. So if the person said, I've been in hospital for the last 6 months, I've just not been, and I've been on a ventilator or whatever, I've just not been in a position, they'd probably exercise some discretion and say, okay, we understand why you couldn't do it. Or if you made them redundant in July and in August they advertised for that position again without good reason, and you wouldn't reasonably have known about it, but no is the answer, really.
Supposing that
tribunals are not that slow.
No.
And even if somehow you'd mislaid it, they'd have written to you, unless you've moved address or something and no one's answering the post, or no one's been in the office since last April, in which case, well, why not? That then you'd have had a default judgment against you saying, well, you haven't responded, so we're going to do something, which would have given you a bit of a clue that you'd missed something.
Peter, can I just ask, because I think it immediately occurs to me, supposing you advertised that job in December,
then probably that they wouldn't do it, but you'd still have to be able to have a reasonably good reason that shows what had changed. But some people sometimes ask me, can I advertise the job again 3 months later? And my advice is, yes, you can, but you seriously increase the risk that someone will say you've just done it as a cunning plan.
Yeah.
And it's not that cunning, because it's easily, tribunals will look. But the law should be on your side, as long as the facts are.
Okay. Thank you, everybody. There was a top 10 article. We did top 10 tip article last year on keeping away from employment tribunals, much of which the structure of this was based on. We are actually sending that out to you when we finish this now. So that will go out to you. Thanks very much indeed for this. We will. There's one Q&A here, so we'll publish that on our website, I think, and we will be back again next week when we will be updating you on what has changed in the past week on the past 2 weeks for coronavirus, and I know there'll be plenty to say there. In the meantime, thanks very much indeed for your time. Peter, thank you for your time very much, and we look forward to seeing you all again very soon.
Bye.
Many thanks for listening today. I hope that you found the session useful. As ever, we finish with the caveat that this is only advice. If you need proper legal advice, then you need to take the appropriate measures and speak to somebody who is qualified to do so. We're very happy to talk to you. Give us a call at any time and we'll see if we can help. We'll tell you what we need to do. In the meantime, I hope you enjoyed this session and we look forward to seeing you again soon.